name the person we want to carry out the terms of the will, the executor. So let me give you an example of a will. With a husband and wife situation, what we commonly see is each of them will make a will, and it'll be the same will for each of them, just changing the names. I leave everything to my spouse, and she leaves everything to me. And at the death of the survivor between the two of us, we leave everything to our children in equal shares. And that's as a basic, simple will. It doesn't have to be that way. You can leave your estate to anyone. You may be married and have 6 children, but you can leave your estate to a charity, a friend, someone else. Of course, it's subject to the homestead rights, but you can leave your estate however you choose. So that would be a typical will. You can say, I leave everything to someone. Or alternatively, you may have a list of personal things. You have family heirlooms. You have a favorite fishing boat. This is a group of hard-working entrepreneurs. You probably, I don't know how many of you, like me, don't have time to fish, would like to, but if you have things, I give my fishing boat to my grandson. I give $100 to my favorite charity. I give whatever, down the list. Then you can say, I give everything else to my spouse, my friend, my relative.
No, it's just a bucket list?
Bucket list, exactly. You can do whatever you want to do. We put that in the will, and that's then the way it's going to pass. It's the deed. That assuming a properly drawn will, then that's what's going to have to take place after death.
So
now,
what if you made a will and do you have to amend the will every time you acquire new things and you remove certain things from it?
Now you anticipated my next point. A will can be amended. We call it, it's one of those spelling bee terms, codicil. Codicil. You might have heard that. 4th graders have heard it because that's on their spelling bee list. Codicil, that's an amendment to a will. You don't have to redo the whole will. You just say, this is a codicil. I change a certain part. I name a new executor. Or I want to leave certain thing to a certain person. Or I want to take someone off the list. A codicil. Or you can just write a new will. Either way. But you can change your will obviously at any time once you make it. Now, what we find is convenient is, let's say it's not easy. I don't even get around to working on my will because I've got too much else to do. It's hard to go see a lawyer, pay a fee, and change the will. It takes time. You can have a codicil. In fact, you can have a will that you make yourself. Now, it's obviously, as a lawyer, I think it's best go to your lawyer, let them do it, okay? But as I said with that back of the envelope, if you don't do anything else, you get out an envelope and you write out what you want on it and sign it. If it's all in your own handwriting, it's called holographic. Totally in your own handwriting, and you write clearly what you want, and you sign it, that can be considered as a holographic will or codicil. And what people often do is we have a will, but then that things change. They don't have the thing they left to someone anymore. They've decided they want to leave somebody something, or their friend or their church. So they make a codicil all in their own handwriting. Okay? Now, if you type an instrument and sign it, that's not going to be accepted. It has, unless you have 2 witnesses For a will to be valid, it has to be signed in the presence of two witnesses who were 14 years of age. As I said, my father was a lawyer, and I remember the first time I had a neighbor who was sick with cancer, and he said, okay, you're 14, come on, and we went over to the neighbors and had him sign his will, and I was a witness at 14. So you have to have two witnesses who are 14. That's part of the rules of we call it execution of a will, but that sounds lethal. I call it signing the will. Now, if you have your lawyer drop a will, he's going to add what we call a self-proving affidavit to the will. An affidavit is a statement that's written up and sworn to before a notary public. So we add to the will this self-proving affidavit that says the two witnesses and the person making the will, we call that person testator. Testator. That's the person signing the will. Those three people swear before the notary that they signed it in the presence of each other, and that the testator was of sound mind, and you have to be 18 to make a will, so it was over 18 years of age. And then that's notarized and added to the will. And if you have that self-proving affidavit, when it comes time later after the person dies to present this to the court will say, okay, it's got the affidavit, so I don't have to have the witnesses come to court to prove they were there and it was signed properly. The testimony is accepted in advance. So it helps later proving up the will. You don't have to have that on the will, but it sure saves tracking down the witnesses. All right, so that's your will. Now, in making your disposition of your estate, you may take into consideration the different contingencies. I give my property to a certain person, but if they predecease me, I give it to the next person, and so forth. So we try to cover contingencies so we don't have to keep coming back and changing the will. And we also take into consideration that you may have children or young people or infirm people, incapacitated people that really would not be capable of receiving the gift that you are leaving them. And in that event, we can prepare a trust as part of the will to take effect at death. When the will is probated, we call it a testamentary trust, a trust that takes effect at death. And you say, well, okay, I have 3 children, for example. I give everything to my spouse, but if she predeceases me, I leave it to my 3 children in equal shares. However, if they're not 35 years of age, or whatever age you decide, the older you get, the longer you want to delay giving them that money. So let's say if they're not 35, then you give that child's share in trust to someone that you name as trustee. And that trustee then is to take the property from the executor, and your trust instrument governs how the property can be invested and how it should be distributed. A typical kind of example would be, I named the trustee. Hopefully it's a relative with some business sense, someone in whom you have confidence, obviously. This is an important position of a fiduciary duty, meaning the highest legal, ethical, moral duty to take care of that beneficiary. I instruct my trustee to take care of the needs of this child until a certain age, and I suggest think of when they would finish college, let's say 23, as an age. Up to that point, the trustee can spend for the health, education, and welfare of that child as the trustee's discretion guides him. At age 23, we might make a distribution of a percentage. It could be any percentage, say 25% of what's left. And then the child takes that gift and has to be on their own, and you could make any number of years, but let's say, to make it easy, 29. At age 29, we'll give them a second distribution of half of what's left. And age 35, give the rest of it. Doesn't have to be that way. You could say, I want the beneficiary to have so much a month, or I want the beneficiary's tuition to be paid as long as they're going to college, or whatever you wanted in the trust. But it's a way of taking care of the needs of that child. And it doesn't have to be a child, it could be an adult too. So that would be something to consider, to take care of your family, a trust. Now, the other significant part of a will is the appointment of not just the trustee, but the executor, and that could be the same person. But usually in a husband and wife arrangement, you would name each other as the executor of the estate, and the executor's job is, and you would name them in Texas as an independent executor. Independent meaning free of court supervision. If you name an independent executor, then they're on their own. The court doesn't supervise, doesn't have to approve every step of what they do. And it frees the estate from having a lawyer involved. People fear the cost, the lawyer fee, that the courts and the lawyers are going to get it all. That's not true if you have a properly drawn will. Your independent executor is appointed, and that person's job is to file an application with the probate court that just simply says, this person is deceased, lived in this county, here's the will. After 2 weeks, that person goes to court for one court appearance in front of the judge. And the judge will read the will, approve the will, and make a finding. This is all important. An order admitting the will to probate, meaning it's a court judgment saying it's a valid will. Once that is signed, the will's effective. The will becomes effective, and the transfer of title takes place. So without that order, even if you have a will, if it's not probated or it's not accepted into probate by signing that order, you're intestate, meaning you have no will. And we go back to what I started out saying, that the probate code takes care of it. So you have to get this court order. Then once appointed, the executor identifies the assets in the estate, pays the debts, and distributes according to what you said in the will, according to the will. That's it. The only other thing the executor has to do with the court is within 90 days of appointment, file an inventory and appraisement, which is simple form, says here's the assets of this estate and the value. And that's it. That's all they have to do with the court. Of course, they have to carry out the terms of the will, and as I said, they're subject to a fiduciary duty, so they can be sued if they don't do it right. I mean, that can happen. But hopefully we appoint someone in whom we have trust and confidence, and they will take care of it. Now, of course, if you're appointing, let's say, a spouse, and she's just serving as executor to transfer title to herself, obviously there's no problem. But there can be litigation that arises. The probate court also has jurisdiction over guardianships. Guardianships are arrangements where an appointment of a personal representative is made, like an executor, to take care of the estate of a minor, because a minor up till 18 can't own property, One of the reasons that we have a trust, if you have a trust, you won't need a guardianship. You've got a trustee. Or incompetent persons. And you can have all kinds of problems in the guardianship area. I have 2 cases in litigation now